Senator Durbin, it's your turn now.
Mr. Chairman, I ask consent to enter into the record 7 articles relative to this hearing.
Yeah, without objection, your articles will be entered in the record.
Thank you. Judge Gorsuch, I sat here yesterday for hours, not nearly as many hours as you sat here, until I reached the point where I could finish your sentences and complete your answers before you. My Republican colleagues assumed the well-known courtroom strategy of never asking a question that could hurt their witness and made every effort to humanize you so that we know your love of fly fishing and rodeos and family. I know that senatorial assignment. I've been there myself. So the Democrats on the committee pressed you for answers to harder questions and tried to peel back your professional and carefully guarded persona so that we might understand whether there's any chance there's a beating heart and an independent streak in Donald Trump's most important decision of his nascent presidency. We were given this public hearing to develop an insight into what it was that made your record so attractive to the Federalist Society, to the Heritage Foundation, and to President Trump. You fended off most questions of substance, so we turn to your written opinions. I'm sure the press and public are puzzled out there why we spent so much time talking about a truck driver named Alphonse Madden, who was fired and blackballed from ever driving again because he was faced with what Senator Franken correctly called an absurd choice of freezing to death or endangering the lives of innocent motorists by driving a disabled truck on the interstate. Many of us still can't understand how 7 judges could look at those facts and the law in the case, and only one, Judge Neil Gorsuch, come down on the side of the trucking company that fired him. Now we have another question that's been raised, and it relates to the Individuals with Disabilities Education Act. It's a landmark law. It mandates access to public education for students with disabilities. The National Education Association took a close look at your record in these IDEA cases. They found that in 8 of the 10 cases to come before you, you ruled against students with disabilities. Furthermore, in one of the 2 cases in which you sided with the student plaintiff, you wrote a concurring opinion, quote, expressing your personal belief that IDEA provides only limited rights to students with disabilities, end of quote. That pattern is troubling. Your opinion in Thompson R2J School District versus Luke P. In this case, the school district appealed the district court's ruling that the district failed to provide a severely autistic child with the educational services guaranteed to him under IDEA. The court ordered the school district to reimburse the cost of a private residential school placement for the child. The district court relied on the expert testimony of autism specialists, psychologists, and occupational therapists to reach that conclusion. They reached the conclusion, quote, the nature of Luke's problems required a residential placement, and, quote, that the reinforcement and consistency Luke needed to make educational progress could not be achieved in a regular school setting at the time. You reversed this district court ruling, and in doing so, you rejected not only the judgment of the federal district court, but also the judgment of a hearing officer and the Colorado State Administrative Law Judge. You asserted that, quote, the assistance that IDEA mandates is limited in scope, end of quote, and that it only requires, quote, the creation of an individualized program reasonably calculated to enable the student to make some progress toward the goals within that program. You also said, and I quote directly from your opinion, from this direction we have concluded that the educational benefit mandated by IDEA must merely be more than de minimis, end of quote. This morning, the Supreme Court ruled on that standard that you established in the case. Here's what they said. In the case of Andrew F. versus Douglas County School District, a unanimous decision by the Supreme Court written by the Chief Justice. Quote, when all is said and done, a student offered an educational program providing, quote, merely more than de minimis, close quote, progress from year to year can hardly be said to have been offered an education at all. For children with disabilities, receiving instruction that aims so low would be tantamount to sitting idly awaiting the time when they were old enough to drop out. The court went on to say, the IDEA demands more. It requires an educational program reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances." End of quote. It's a powerful decision. It's a unanimous decision. It was written by the Chief Justice of the court. It is an issue which we need to face in America with the incidence of autism and children with severe disabilities. Why? Why, in your early decision, did you want to lower the bar so low to merely more than de minimis as a standard for public education to meet this federal requirement under the law?
Senator, I really appreciate the opportunity to respond to that because I just saw the opinion was handed to me as I was headed to the bathroom a moment ago. I guess it was just handed down. Let's start with the Luke P. case and work forward from there. Luke P. Was a unanimous decision by my court. It included on the panel of 3 judges an appointee who happened to be appointed by a Democrat president. There was no dispute in my court about the applicable law, and there wasn't because we were bound by circuit precedent, a case called Urban versus Jefferson County, 1996, that said that the appropriate standard was de minimis. It had to be, the educational standard had to be more than de minimis. That's the law of my circuit, Senator. And I've been asked an awful lot about whether I abide precedent and whether I always like the results I reach. Here's a case for you.
But I might
Senator,
add,
Senator, if I might finish.
Sure, of course.
I'd appreciate the opportunity to finish this. If anyone is suggesting that I like a result where an autistic child happens to lose, that's a heartbreaking accusation to me. Heartbreaking. But the fact of the matter is I was bound by circuit precedent, and so was the panel of my court, and had been bound for about 10 years by the standard in Urban versus Jefferson County. Now, Senator, there are other cases where, again, unanimously, my court had ruled for children with disabilities under this law. School of Deaf and Blind, another Jefferson County case, are examples where I joined, participated, or wrote in idea cases for the family under our binding standard. I understand today that the Supreme Court has indicated that the Urban standard is incorrect. That's fine. I will follow the law. Now, sometimes, I think it was Justice Jackson who said, just because I made a mistake unknowingly yesterday doesn't mean I should make a mistake knowingly today. I'd invoke him here. If I was wrong, Senator, I was wrong because I was bound by circuit precedent, and I'm sorry. But I'm trying to apply the law, and I can tell you that we were doing it unanimously in all of those cases. And the Supreme Court is our boss, and we respect their last word. They are final.
Judge, in 8 out of 10 cases that came before you, you ruled against the students with disabilities.
I'm sure there were unanimous panels.
And the
Senator,
difference in this case, the difference in this case is about a word. We know that words are important, and they can make a critical difference in a person's life. You can ask Alphonse Madden that question. The word that you inserted into the circuit standard when it came to these cases was merely. Merely. I would say most people reading that would say you have pushed the de minimis statute even further down the standard pole. And it was that word, merely more than de minimis, that was specifically overruled by the Supreme Court. So my question to you is, if you wanted to just stick with 10th Circuit precedent, you felt your hands were tied, why would you add the word merely to modify that?
Senator, all I can say is what I've said to you before, which is a unanimous panel of the 10th Circuit following 10-year-old circuit precedent, including Democrat colleague. I don't view my colleagues as Democrats or Republicans, followed our circuit precedent. And these cases have been decided unanimously. I think all of them, if I had to guess, that you're pointing at. And to suggest that I have some animus against children, Senator, would be mistaken.
Judge, please, I'm not suggesting that. You are,
To hear it.
what I'm basically saying to you is, I can only look at your court opinions, the words you write, because like many nominees, you are careful in your testimony before us. And we have to look at your words and try to look into your heart with these words. And when I look at that word merely, it troubles me. Do I believe you love your family and love children? Of course you do. But when it comes to applying the law to a truck driver blackballed for life from driving a truck, when it comes to applying the law, when it comes to a family, I cannot imagine the pain they're going through with an autistic child. I want to try to understand what Neil Gorsuch's heart is leading him to. You've told us time and again, no place for my heart here. This is all about the facts. This is all about the law. I don't buy that. I don't think that the decisions of courts are so robotic, so programmatic, that all you need to do is to look at the facts and look at the law, and there's an obvious conclusion. If that were the case, there'd never be a dissent.
Senator, there was no dissent in that case.
Well, in other cases, there have been dissents, and you've written them. And the point I'm making to you, like the case with Trans Am, is we're looking for an insight into your values and your judgment. And it's hard in this kind of hearing to get close to it. Let me take you to an issue I raised yesterday about your mentor and supervisor at Oxford, Professor Finnis, who, as I understand it, helped you write your doctoral, or at least moderated the writing. I've never gone through this experience, the writing of your doctoral thesis, which led to the publication of a book on euthanasia. Is that correct?
Senator, he was my dissertation supervisor. He wrote none of my book, and I've written none of his work.
Would you say he gave you kind support through draft after draft?
Absolutely,
That's
as every
exactly
good
what you said.
dissertation supervisor would do.
So I guess what I'm driving at is this. There is a statement which you made in that book, which has been often quoted, and I want to make sure that I quote it accurately here today. Give me just a moment to make sure I find it. It relates to the taking of life. I'm sorry, I'm having difficulty finding it on this page. And I quote, "The intentional taking of human life by private persons is always wrong." That was a statement that you included in your book, correct?
I believe so.
I believe so, too. How could you square that statement with legal abortion?
Senator, as the book explains, the Supreme Court of the United States has held in Roe versus Wade that a fetus is not a person for purposes of the 14th Amendment. And the book explains that.
Do you accept that?
That's the law of the land. I accept the law of the land, Senator, yes.
I think that's an important element to bring into this, because when you were questioned by Senator Coons about this whole area and asked why you would express an opinion, and you said, I wasn't a judge at the time, I was a commentator. So that's another brief opening of a narrow door here to an insight into what you were thinking. And I wanted to have some clarity on the record when it came to that. Sure. Thank you for that clarification. Let me ask you about the Sixth Amendment. In 1961, Clarence Earl Gideon, accused of stealing money from a pool room cash register in Panama City, Florida, asked for a lawyer. His request was denied. He represented himself and was sentenced to 5 years in prison for petty larceny. Took his case to the Supreme Court, which held unanimously that the Sixth Amendment entitled Clarence Gideon to a lawyer. In 1963, the retrial took place, and then represented by counsel, Mr. Gideon was found not guilty. Judge Gorsuch, do you agree that the Sixth Amendment right to counsel is fundamental?
As recognized by the United States Supreme Court in Gideon versus Wainwright, Senator, yes.
Have you ever written an opinion finding that a defendant's Sixth Amendment right to effective assistance of counsel was violated?
Oh, I'm sure I have, Senator.
You've offered 52 opinions that discuss the Sixth Amendment generally, according to the Stanford Law Review. In none of these did you find that an attorney provided ineffective assistance of counsel in violation of the Sixth Amendment. Further, according to this Stanford Law Review article, you've dissented 4 times in Sixth Amendment context, each time with reasoning that favored the government. I'm concerned that whether you appreciate the importance of this fundamental right. Let's take the 2009 case, Williams versus Jones. Mr. Williams was offered a plea agreement of 10 years. His lawyer threatened to quit if he accepted the agreement. He advised Mr. Williams, if you took a deal and pled guilty, that would be perjury. That was clearly false statement by his lawyer. Mr. Williams relied on that misinformation from his lawyer. He lost at trial and was sentenced to life in prison without possibility of parole. When Mr. Williams' case came to the 10th Circuit, you were the lone dissent. Your colleagues, Judges Kelly and McConnell, both Republican appointees, disagreed with you. And then in 2012, the Supreme Court disagreed with you too. In Lafler versus Cooper, Justice Kennedy wrote the opinion holding that, quote, prejudice can exist if loss of the plea opportunity led to a trial resulting in conviction on more serious charges or the imposition of a more severe sentence. The Supreme Court noted that 97% of federal convictions, 94% of state convictions end in guilty pleas. So the accused, even before a trial, must have the competent guidance of an attorney in deciding whether to take a plea deal. In light of Lafler versus Cooper, please tell me what you feel about your lone dissent in Williams versus Jones.
Be happy to. So, Senator, under the Sixth Amendment Strickland test, before you reverse a conviction or a plea deal, you have to find 2 things. First, you find whether there's ineffective assistance. But that's only part of the equation, because the Supreme Court, Justice O'Connor said, we don't reverse where there's no prejudice. So you have to show prejudice as well, ineffective assistance plus prejudice before reversal occurs. So oftentimes you'll have cases where there was ineffective assistance, but at the end of the day, you can't say there was a harm or a foul. Now, that's a counterfactual hypothetical that you have to ask yourself, and it's a hard question.
Did you feel there was ineffective assistance in the Williams versus Jones case?
In Williams versus Jones, the question was one of prejudice in my mind, as I recall.
You said there were 2 tests. I asked you about the first one. Did you feel that this defendant had ineffective legal assistance?
I don't recall what I said on that subject. What I do recall saying is whether there was or wasn't ineffective assistance with respect to providing the plea deal, communicating it to the client. The gentleman had a fair trial, and he had what everybody admitted was a full and fair trial.
But that wasn't the point of the case, not in that case or in Lafler. And the facts say on ineffective assistance are clear. His lawyer threatened to quit if the defendant accepted the plea agreement and advised his client that if he took a deal and pled guilty, that would be perjury. That was false. That is, in my mind, prima facie, ineffective assistance. Was there a prejudice? Oh, I think there was. A choice between a plea deal of 10 years or life in prison?
And Senator, the question was whether there's prejudice in light of a fair trial that took place. And that was the question that the court had to consider. I think I accepted that there was deficient performance or ineffective assistance. And the question was one of prejudice. And the Sixth Amendment is about a fair and free trial for all individuals. And this gentleman, by everyone's admission, had one. He admitted he had a fair trial.
But that's
so,
not the point.
Well,
the point is
that
he was misled by the incompetence of his counsel to turn down a 10-year plea deal, misled, led to trial, which might have been fair on its face, and a life sentence at the end of the day. And the Supreme Court clearly, you were the lone dissenter in that case at the circuit level, the Supreme Court clearly decided that you were wrong with Justice Kennedy's opinion that I read.
It was a 5-4 decision by the United States Supreme Court.
And the point?
Closely divided decision, and you're absolutely correct that Justice Kennedy wrote for the majority and said that in the context of a plea deal, even if there is a fair trial, prejudice will be presumed on the basis of a plea that might have been accepted, could have been accepted, that could have averted a fair trial. And that's the standard, Senator. And since the Supreme Court's announced it, I have faithfully applied it.
Thank you, Mr. Chairman.